This is Toasted with Revolution News and Information. I'm going to pass the floor over to Judge Doucette so he can introduce his show and tell you about what's going to be going on tonight. I yield.
Thank you, Toasted. Welcome, everybody, to another Sunday night. We should have a pretty packed show tonight. We've got a couple of topics that we want to talk about. The first one we'll start with, we'll probably get into that. The second one, which I also announced on the Facebook page, we may have time to get into that this week, and we may not. We may be able to touch on it a little bit. But so the first topic that we're going to be talking about is going to be court of records and how to do court of records and the success that we've been having with those and all of that. The second topic is going to be more spiritual. We have all learned, people, that there are a lot of things that we have been lied about and lied to, and that we thought we knew the truth on different things, especially the government. We thought it was our government and that they were here to protect us, and none of that could be further from the truth. And everybody needs to remember that this is a spiritual war that we are fighting. And because of that, I've had to go back myself and take a second look at the Bible itself. And I had actually, done a lot of research on Scripture and all of that before I got into law and all of that stuff, and I thought I knew it well. And the last couple of years, I've been taking a harder look at things. And you people all know that I'm very spiritual about things, but you also know that I don't like to talk about things until I really feel that what I'm saying is the truth. And for those of you that know or don't know, I'm very much a spiritual person. I believe in our Heavenly Father, the Creator, and that He brought His Son here to save us all. But I don't believe in any religion per se. I do believe the Bible. I do believe the Book of Enoch. There's a lot of good Scripture out there. And even in that Scripture, the Bible itself, it's amazing. I mean, our Creator is trying to show us the truth in everything. But sometimes we don't see that truth until we go back and translate it for ourselves using the original Hebrew words. Things are not what we think they are in the Bible. And that's why there are so many words that have so many different meanings. And when you start doing Bible studies and plugging in the other meanings for those words, a whole different Bible opens up. So anyway, with that said, we'll get into that subject later on in the show if we have time. But there's a very good chance, people, that who you think is God or Heavenly Father or Yahweh is not who you think it is, and that we've been deceived about that as well. Now, this doesn't mean that there isn't a God and that there isn't a Jesus Christ, because there is on both of those. I'm not saying that. I'm just saying that we may have very well been deceived as to who we're praying to. Anyway, with that being said, I would like to open this up with a prayer, and then I'm going to hand the conversation over to Roger Dowdell. Dear Heavenly Father, the Creator of the heavens and earth and everything that is and ever will exist, we thank you for the wonderful blessings that you have brought to us. We thank you for showing us the truth in the corruption and for giving us eyes to see and ears to hear. We ask, Heavenly Father, that you would open up everybody that is on this call, open their hearts, minds, bodies, souls, and spirits. And that you would remove all evil that would hurt and harm anyone.
What you got?
And that you would fill us with the Holy Spirit. Toasted, can you grab that for me?
Oh, yeah.
Who was it?
What?
So their son was.
Yeah. It's
I don't see him on
guys,
my board.
Oh.
Hey guys, we're in the middle of a prayer, so if nobody is talking, please mute out.
no. I'm gonna do it. I'll take it off and do it.
All
Okay.
right. I just put them on hold. No
Okay,
more
good.
of that. Go ahead.
Thank you, sir. Anyway, Heavenly Father, we ask that you would fill us with the Holy Spirit, and that you would fill us with the pure love of the Holy Spirit, and that you would put each and every one of us as armor of protection on us each and every day, and that you would show us all the way to be found righteous on your coming. Again, Heavenly Father, we thank you for all of the blessings and all that you've shown us. We ask that you make this so. Okay, Roger. Am I still on? Is anyone there?
I hear you.
I hear you.
Okay. Roger, I'm going to turn the floor over to you, sir, and I will mute out. Roger? Roger Dowdell. Toasted, are we having fun with the call tonight?
I don't know. Let's unmute people and see what happens.
Okay. Yeah, because
Okay,
obviously
no.
I'm not getting at Roger, and I know he's there, so.
Yeah, somebody had some background noise, and
Right.
Roger, are you on the phone?
Sorry for the technical difficulties here, people, but we'll get this in a second. Roger Dowdell, are you there?
Roger, if you're on the main call board, please hit ***.
Can you hear me?
Yes,
Yeah.
Roger, there you are.
Okay, I was muted out, and I didn't know how to get off of mute.
Okay. I will turn the floor over
Sorry.
to you, sir. All right?
Great, thanks, Bruce. Yep, so tonight we have a couple of guests. As Bruce mentioned, Justice Hamilton, Justice Tadlock, and what we'd like to cover is a few basic questions about what is a common law court of record, when is it appropriate and applicable, how does it really work, and then an example that both justices have been working on recently in a foreclosure case in Colorado. So I'd like to turn it over to both of you folks, if you could remember what it is, the characteristics of a common law court of record, when is it appropriate to be used, how does it really work, and then an example.
Okay, Justice Tadlock, you want me to lead?
Yes, you lead.
Okay. Before I get into that, there's a few definitions I want to review with everybody to familiarize them with some of the common law terminology, starting with the term common law. Definition of common law is that which derives its force and authority from the universal consent and immemorial practice of the people. See Law Common, Bouvier's 1856 edition. Court of Admiralty. When you walk into any court that has a gold fringe around the edge, you are in a court of admiralty, and that's what you'll find in almost every single physical building in the United States of America. There are some physical buildings that keep one room, like in California, without this gold fringe. The definition of a court of admiralty is a court having jurisdiction of all maritime causes, vide admiralty, courts of the United States, instance courts, prize courts, That's in Bouvier's 1856 as well. And there's actually a case site associated with that. There was one more I wanted to cover. Praecipe, an original writ drawn up in the alternative commanding the defendant to do the thing required in order to show cause. Now, a court of record has 4 different criteria, and I'm going to talk about there's a 5th criteria, which is actually an optional one, which is the court may have a seal. 2 of those criteria I'm not going to cover because you can look those up in any Black's Law Dictionary up through the 8th edition and find the 2 criteria that the powers that are trying to control information want all of us to believe. The 2 criteria that they eliminated in the 5th edition of Black's Law Dictionary that you can still find in the 4th edition and previous are proceeds according to the common law, and the duties of the magistrate are independent of that of the tribunal. That means the judge is not allowed to make any decisions. The judge's sole duty is to make sure everybody plays nice and by the rules in the court. That's all he's allowed to do. Anytime, first off, we have to all remember that in common law, if there is no injury, there is no crime. As such, first off, under common law, people are not required to abide by statutes because statutes do not apply to them, not specifically named. You will not find in researching any statute the term people used in the statute, nor will you find a statute that requires natural persons to do or not do anything. These statutes are all written strictly for persons, and persons do not refer to people, and there's case law to back that up too. As a matter of fact, let me cover a couple of those because this is all relevant to knowing what you're doing when you go into a court of record. Let me I got to change pages here real quick. I'm going to jump down to the case law page on my site. And you can find a lot of case law on freecountry.com under the income tax menu, which I probably need to move this. You'll see a reference, a link to case law. And there's a table at the top that has lots of different categories to look at here. But I forgot which one I was just going in to look at. People are sovereign. Hold on a second here. Persons and people. Okay, there's actually a number of case laws like Church of Scientology v. U.S. Department of Justice. The word person in legal terminology is perceived as a general word which normally includes in its scope a variety of entities other than human beings. Wilson v. Omaha Indian Tribe. This is also cited in numerous cases. William v. Michigan State Police. The word person, as used and employed in most statutory language, is ordinarily construed to exclude the sovereign, and that for one, as such, to be bound by statute, they must be specifically named. In United States v. Cooper and United States v. Fox, government admits that often the word person is used in such a sense as not to include the sovereign, but urges that where, as in the present instance, its wider application is consistent with and tends to effectuate the public policy evidenced by the state, the term should be held to embrace the government. So when you see a statute say refer to person, the government is bound by that, and government employees are bound by that. In United States v. Latcher, the legislature cannot be deemed to have intended to punish anyone who is not plainly and unmistakably within the confines of the statute. That kind of explains why if the term people is not used, the statute does not apply to people. It applies to persons. You will also find, reading almost every single constitution in the United States of America, the term people is used any time that people's rights are being protected. And in every instance that the government's authority is being expanded, it's expanded over persons, not people. Why would they differentiate in the same Constitution between people and persons? It's because people are sovereign, not to be confused with sovereign citizen, which doesn't exist. Everybody use the term sovereign citizen needs to stop using that because it doesn't exist. Citizens are by definition subjects. But the government has no authority over people because people are sovereign, and your rights are everything that you individually determine those rights to be. So the way that you protect those rights is to proceed in the court of record. A court of record, by definition, as I said, proceeds according to common law, and the duties of the magistrate are independent of that of the tribunal. Now, when you file a counterclaim, and you have to remember also, there's a couple of other terminology that you have to be familiar with. The term plaintiff is a term of equity. When you file a claim at law in a court of record, you are either a claimant or a counterclaimant. You are not a plaintiff or a counterplaintiff. All of your opposition are still defendants. And you will find, as a matter of fact, when you file an action in federal court, in a court of record, the opposition commonly tries to start referring to you as a plaintiff when they file a motion for dismissal or anything else. What we do in our when we correct the court is we point out the term that the claimant filed an action at law, and claimant is a term of law, and plaintiff is a term of equity. We like to clarify in the record where we stand. We commonly find, at least on the federal level, once we remind the judge that he is not authorized to make decisions, the judges at the federal level tend to be honorable. But this is how typically things proceed in a court of record. If anybody is being attacked by government for violating a statute, we have to remember what a couple of different things are for. Like, for example, let's say somebody got arrested for driving under the influence. You'll be taken in front of a judge or a magistrate, and the judge or magistrate will say something to the effect, you're hereby charged for violating code such and such. How do you plead guilty, not guilty, or no contest? As though those are your only three choices. They are not your only three choices. What the judge is attempting to do is to get you, the sovereign, to consent, as required in a republic, to leave the confines of the common law and submit yourself to the statute. You have another choice, and that is to object to the code. When you object to the code, what you're saying is, I don't consent to leave the common law. I prefer to stay right here where I am. If the judge enters a plea for you, the judge has committed perjury. He's violated 18 U.S.C. 241, which is conspiracy against your rights. He's violated 18 U.S.C. 242, which is deprivation of your rights under color of law. Color of law is the pretense of law, but it's not law. And he's also committed a couple other more serious crimes, including treason. So the correct next action if something like that happens is to file a counterclaim in a court of record. When you file a counterclaim in a court of record, all it takes to make it a court of record is in the very first sentence. You say, comes now Michael Hamilton, a people of Louisiana or Kentucky or wherever, of sound mind, which advertises, no, I don't need an attorney, in this court of record. And because the sovereign of the court chose the common law as which in a court of record, that's his choice. What commonly happens in our cases is we'll file an action in the court of record, what most commonly happens is the opposition, especially if it's a state, and we always recommend including the state because one of the objectives of filing a counterclaim or a claim is a declaratory judgment ordering the state to remove the sovereign of the court from its jurisdiction, because the state has no jurisdiction over people. And what we're doing here is working to get the state to update its records about the sovereign of the court in whatever grouping of letters and characters it uses to identify the sovereign. So commonly the attorneys representing the state will move the court to dismiss the case for sovereign immunity. But no fictitious entity, whether it's the IRS or any state is sovereign above people. People are the highest sovereign in any of the states in the United States. So we challenge that. What we'll commonly do is, if the judge dismisses the case first, we'll file a writ of error, and in that writ of error, we'll provide all of the lawful arguments in the case law that point out to the judge why he's not permitted to make a decision. And remember, when you file a counterclaim, the basis of the counterclaim is jurisdiction. All of the arguments should be arguing what injuries were caused to the sovereign by being detained for driving while inebriated, or whatever the cause might be, whether they're trying to take your children or your house for foreclosure, or whatever the case is. All sovereigns deserve to be heard in a court of record. And as such, if the judge makes a decision, the next thing that the sovereign of the court is going to do is correct the judge and submit his own. Now, you have to remember, if you're the sovereign of the court, you don't let the judge make any decisions for you or against you. Even if the judge makes a decision in your favor, that needs to be corrected, because he was not authorized to do it. And if you let him get away with making a decision in your court, in an order in your court, even if it's in your favor, the court is not proceeding according to common law, and as such is not a court of record. So commonly in federal court, the judges behave honorably once they get this correction, and we no longer have an issue with them, as happened in Justice Tadlock's case. 2 different federal court judges behaved very honorably and stopped interfering with his case. Even though multiple occasions the opposition submitted motions to have Justice Tadlock's orders stricken from the record, the judge did not interfere and did not strike those orders, because he knew that Justice Tadlock was going to be denying those motions to strike his orders in his court. And that's what you have to remember too, is when you're in a court of record, it's your court. A court is by definition the person and suit of the sovereign, and you're the sovereign of the court. As a matter of fact, that's exactly, a lot of people wonder why, when I explain to people all the time that there's no law requiring the American people to pay income tax, why the IRS succeeds in getting people put in prison and taking their houses and their property from them. And this is how they do it. I don't remember the specific section, but there is a section of Title 26 that specifically states that the tax court is a court of record. So what the IRS does is it files an action in a court of record. It doesn't state specifically it's a court of record, because the section that it's required to abide by already says if it's tax court, it's a court of record. So the IRS submits to the court its documents decreeing the law. They decree that you are a taxpayer. They decree, as a taxpayer, you owe them X amount of money. And if you act as a defense, as a defendant, and you say, show me the law, or try to bring up case law or Supreme Court cases the judge is not going to allow that because those were not decreed as the law by the sovereign, in this case the IRS. The correct way to overcome any attack in tax court by the IRS is to file a counterclaim in a court of record challenging jurisdiction because, as I previously stated, no fictitious entity is sovereign above people. That's the one argument they cannot once ever overcome. In all the cases that I've prepared documents for, not one single time has any opposition ever overcome the argument that people are sovereign. We've got case law that backs that up and supports it. So that's how the IRS wins and how to beat them. Eventually, you'll be issuing a judgment in your court. The only way that your defendants can get around the sovereign of the court making the decision is to request a jury. And in a court of record, in common law, the jury is selected strictly by the claimant or the counterclaimant, the sovereign of the court. And the sovereign, being a member of the peerage, does not need to permit anybody who is a U.S. citizen sit on his jury, because the sovereign is above all other people, and he may only be judged by other sovereigns, other free people, members of the peerage. Matter of fact, a member of the peerage, I had it here a minute ago on the definitions page, but the peerage are members of the free people. They're members of the nobility. A peer means the equal of a people who is a free people and a sovereign. So we don't allow citizens who are by definition subjects of government sit on our juries. So anyway, I think that pretty much covers what a court of record is and how it operates. You file a claim or a counterclaim. The judge makes a decision. You issue a writ of error, and you have to have the same attitude that you would have if I came into your house and I sat in your easy chair and ordered you to bring me dinner and a beer. What would your attitude be like? That's exactly the attitude you have in your court. It's your court. When you file a claim at law, it is your court. The purpose is for you, the sovereign, to prove to the rest of the world that you're right. That means you do have to be fair, but it's still your court. If the opposition submits some kind of argument claiming that your claim is invalid, you deny the motion. If the judge grants their motion, you overturn his order. He's not permitted to make an order. In all of our cases, as a matter of fact, our writ of error includes an order that specifies if the court gets any further interference from any of the court officers, including the clerk, the magistrate, or the court administrator, he will be held in contempt of court without hearing and without motion. We don't tolerate insubordination from any of the court officers in a court of record. And if they do, we do hold them in contempt of court. If somebody violates your order in your court, it's your responsibility to hold them in contempt of court. That's actually one of the two definitions you'll find in a current version of Black's Law definition. Can hold people in contempt of court. And that's why you as the sovereign will hold insubordination from officers of the court in contempt of court. Eventually, you'll issue an order in your court in your favor. And again, if they don't want to have that happen, they have to demand a jury trial, and no U.S. citizens are allowed to sit on my jury because they are beneath me. They are subjects of government. They are not free people, and only free people may sit on my jury. I get judged by my equals, not by inferiors. Anyway, Justice Tadlock.
Yes.
you're up. Tell us about your case.
Okay. Well, I am I should not in anymore. My case is over. We wrote judgments in our favor in 2 courts of record. But I was blessed to meet with Justice Hamilton before we knew what justices were, actually.
Yeah, both of us.
And we were fighting this. I was fighting this by not consenting and letting them know that I wasn't a person, I was a people, and challenging jurisdiction. And at the time where I had my meeting with the Colorado Rule 120, which is really just a way for the state to steal a house without anybody having any standing. All they have to do is present that something was in default, even if they aren't the holder of due course. Then they say, well, since it's in default, and they are allowed to foreclose, even if the bank has no standing at all. So it's definitely weird in Colorado. They violate due process all day long to steal property. So I was doing pretty good on my own, just challenging jurisdiction. And I met with Michael, who just explained what a court of record was, and the light bulb hit. Said, of course, this is the way to go. And so I challenged the jurisdiction in court, in their court on December 11th. And he tried to gaslight and say I was crazy, making up names with the terms, persons, and people, that I was playing word games. But they did not try to sell. Even though he wrote an order, they did not try to sell. And so on January 4th, about almost a month later, I challenged jurisdiction in a court of record, and they had no idea what to do. We included everybody: the bank, the lawyers for the bank, the state, the county, anybody that's involved. And they, just like Michael said, tried to dismiss the case using their statutory rules and procedures, and we dismissed them all. And the bank just sat back and waited to the last day, because they just saw that everybody was being denied in this court of record, and they tried to remove the case to a inferior United States District Court with a judge, so they can get someone who could actually listen to their arguments, is what they told that judge. The court of record denied that removal of the case from its court, and proceeded with the proceedings at law, and vacated the order from the inferior court selling the house, and also ruled in favor and dismissed the case of that case. And so, so we sent those rulings to the United States District Court that they tried to remove it to, and they started playing in Colorado. The state courts are very, very wicked, and they also are just crooked. And so they started removing all of our orders, violating what is that statute, 2071?
That's right.
Right. So they started removing
18
all. Go ahead.
It's 18 U.S.C. 2071.
Right.
It's a crime punishable to 3 years in prison for removing documents from the file.
So they realized the only way to beat us was to cheat and start removing files. And unfortunately for them, I had everything stamped. And so in a court of record, once something is filed, it cannot be removed. That's one of the requirements that Michael read. And so we turned around and gave that to the the United States District Court of Record. They tried, or not record, the inferior court. They tried to remove it to, and we sent a notice of judgment from that Adams County State Court, our court of record, to that judge, and he immediately, with those orders, and he immediately scheduled a case hearing, a case status hearing. And in that case status hearing, he began to try to say that pro se, tried to call me a pro se. He tried to, get me under his jurisdiction, and we stood strong, letting him know that we weren't persons, even though he was trying to convince us that we were, and that we're people, and we don't consent, and the case is over. He has no jurisdiction because the court of record is the highest court in the land, and we use the United States Supreme Court ruling backing us up on that. And so he asked the bank actually why, after he told me, well, you guys you pro se get in trouble because you don't use arguments where I can help you. I told him, well, I don't need your help. They do. They tried to remove the case because they did not like the jurisdiction, the court of record that we filed the challenge in. And so he looked at them and said, well, why did you try to remove the case to my court? And they agreed. They said, we wanted to have a jurisdiction where our arguments would be, where a court would look favorably on our arguments. And so he kind of shook his head and basically told them, well, he's not going to consent. I don't think he's going to consent. He's not going to consent at all on this, so I don't know about this. And then he tried one more time and basically said, hey, so I sent you an order where you have to tell us why we should not dismiss this case. And you should have, any good lawyer would have anticipated that you would have to, that they would try to dismiss your case. You have until the 26th of May to answer this. And so went home, saw the order that he sent me, and it was a minute order, which is not an order. And so we sent a cease and desist to him. He was expecting us to see why this was not going to be, or to be dismissed. We sent a cease and desist, and that this case was already, there was already a judgment in this case, and he couldn't review it. And we went through all of the points where it reversed all the points where he was trying to say we were pro se and plaintiffs and all of this. And he, on July, I guess that was a month and a half later, decided to rule that he did not have jurisdiction and could not interfere with our court of record, and remanded the case that was never removed back to Adams County, where they had already lost. So he actually realized that we knew what we were talking about. Court of record is the highest court in the land, and he told Wells Fargo, the bank, that he can't do anything for lack of jurisdiction, and that he got advice. So he wasn't making the decision on his own, that he actually got advice. And so Wells Fargo, of course, decided to, tried to repeal it, tried to repeal it. And another judge backed him up on October 4th and closed the case. So their attempt to remove our court of record in the state failed, and they lost that case. And so we have judges that are backing us up on that. And the only portion that we're waiting on now is to get the trustee to abide by the rulings of the court, but the judges have. So hopefully I didn't bore everybody. I was trying to remember and do it in chronological order, but that's kind of what happened.
Yep.
Did I miss anything,
if I may? Well, I wanted to point out there's a couple of things that happened that actually showed support from both federal court judges. First off, the judge in the inferior federal court, and by the way, inferior court is by definition any court that uses statutes because it does not proceed according to common law. And what you have to realize when you see the title Superior Court, a lot of their courts are called superior courts, but if they're still using statutes, they're not in fact superior courts. They're still inferior courts. A superior court, by definition, proceeds according to common law. But the minute order, as Justice Tadlock pointed out, is not an order at all. It's a note for the judge or the clerk. It was 26 points that this judge was making. One of those was Colorado has sovereign immunity. He called Tadlock a plaintiff. He called him, said he was pro se. And we countered each and every single one of those points, and we had case law to back up most of them. And I think it was at that point that the judge realized he was not going to be able to take jurisdiction, and as a result, he did start obeying the orders of the court. And I think he only took a long time to remand the case back to the district court of record, because he wanted to make sure he had statutory arguments for doing so. But the judge in the superior court of federal court of record, once he got his first writ of error, also started acting honorably and abiding by the law. And at one point, the bank submitted an objection in the inferior federal court, objecting to the case being remanded back to the state district court of record. And that was when they also submitted another motion to strike Tadlock's orders in the superior federal court of record. And this is the way that judge responded. The judge in the superior court of federal court of record went into the inferior federal court and upheld the inferior court's, the federal court judge's decision. And he did not interfere in his court because he knew that the tribunal of the court, the sovereign of the court, was going to handle it as he had been before. So he sent a message there. He sent two messages there. One is, the case in this inferior court is closed. Don't do it again. And I'm not interfering in this court over here. I'm not allowed to. He basically supported Tadlock by not interfering with his case. So what we've done is shown as a matter of fact, the federal court of record ordered the state district court of record to restore the record, and that was done as well. And apparently the state district court spoke with we're speculating that the state district court spoke with the federal court judges, because he started behaving honorably as well once that happened. I mentioned earlier, I wanted to give you the definition of a peer. A peer is one who is a member of the peerage, i.e. the nobility. A jury of your peers is a jury of your nobility. In America, everyone is a king without any subjects, so a jury of your peers means a jury of people, the owners of the country, not citizens who, by 14th Amendment constitutional definition, are all publicly owned slaves.
If I may.
Yes.
Yes. One other thing I wanted to say, this is Justice Tadlock, is that not only did we give them the laws and cases of why he was wrong and we were right, according to the case law, but we also used the Title 18 and all of the statutes that bind him if he goes against the common law or any or the Constitution. And I believe that also, because we listed several Title 18 violations if he did not follow the rulings of our court of record. It was a combination of the case law, the common law, but also holding their feet to the fire, putting a little bit of teeth into what we have as well.
May I?
Yes. Sure.
This is Justice Doucette. Roger, I think now would be a good time to bring people on and let them ask their questions about Court of Records, but I'm going to yield to you, sir.
Agreed.
Okay.
Just one last question, and we'll open up for questions. What are the next steps in front of us, Justice Tadlock, please?
The next steps, we are doing what we realized is that we'd never sent a dismissal order to the original case. We just dismissed it in our case, but we never did what we did to the United States District Court, where the judge initially was trying to get us into his jurisdiction and send a minute order. We actually sent notice to his court, so it was on public record, that the case was already adjudicated and that he had no jurisdiction. And so the next steps, because I'm learning as we go, is that we are going to have that initial court dismiss his case based off of the ruling on the case that challenged his jurisdiction.
And Tadlock, if you would you discuss how you guys are going reprimanding Wells Fargo Bank, please?
Yes, and not only that was part one, is we're going to tell the original court to dismiss his case or else, just like we did with Schaefer's United States District Court. But we have secured the damages from both the state and the United States District Court, damages that are now over almost $5 million, $4.7 million. Secured them with common law liens that they cannot remove. And we sent them a foreclosure, intent to foreclose, just like they did anybody else. They fell in their own snare, and we used their exact language against them. And they did not, of course, they ignored it. And so now we're going to foreclose on Wells Fargo's property to satisfy the notes, to satisfy their damages that they owe us. So those are the two things that we're going to file tomorrow in our court, and then we're going to notice the original court that they need to dismiss the case.
And is it fair to say that when you record something in your court, you are putting it into the official public record? Is that not where your paperwork gets filed?
Yes, that's fair to say. Not only fair, that's true.
And before you do that, do you also make sure that it gets stamped as recorded?
Yes, although we get everything stamped. And so now they sometimes if they see that a judge has that it's an order, that they deem it an order, they'll file it as received, which is the same thing as being filed. But most of our documents get filed, stamped as filed, because we kind of hide the fact that they're orders. Because it doesn't have to say order on the first page. As long as there's an order on the back page, it's an order.
Got it. Okay, I'd like to open up for questions and answers for either Justice Hamilton or Justice Tadlock. The subject matter is the Common Law Court of Records. Yes, you may.
This is David in Michigan, and I've executed for the last probably 18 months a lot of the same things I just got through hearing there, right down to the liens and the in common law, and I got my own common law court of records. And I'm now, I'd like to find out where hopefully you've got it posted publicly, these liens and how you're going to collect on both Wells Fargo as the counterclaim and the claimant, and the district court and the state court, and how you want to foreclose and things like that, because I'm at that point right now with my liens as well, and would like to know how to go about doing it properly without ending up behind the bars.
Did you get a judgment in your case?
I did a default judgment, yes.
Okay. You have a judgment that backs up what you're doing. As long as you proceeded in the court of record, that's a legitimate order. File your common law lien. Now, in our common law lien, we defined a number of things. I started out with a common law lien off of Bill Thornton's site, and we stripped all the UCC quotes out of it because we're in common law. If it's a common law lien, we don't quote statutes. Statutes don't apply in common law. But we also did, however, keep the definition of what a dollar was, and a dollar was defined in the Coinage Act of 1792 as 371.25 grains of silver. So they owe a lot more than they thought they did because they didn't know what the definition of a dollar was. They didn't know what the definition of a court of record was. They didn't know what the definition of a dollar is either. But you file the lien, and then you send a notice. A notice and demand that you want to be paid. After you file the lien, you want to be paid. They got 30 days to pay you. You're going to start foreclosure proceedings.
Right. I use a notice of intent to foreclose just like they used on me. I just copied their letter and put their name in it.
Mm-hmm. That's it.
Yep.
Okay. Now, all right. Well, I'd like to take, is there a way that I might be able to get some coaching on the side? Because I think I'm a lot further along than most of the listeners here. And I've already gotten all my documentation in order, and I sure could use some coaching at this point.
Sure. You can contact me through a free country.
Okay.
At freecountry.com. Michael at.
I can either get information from Florida, or I can get it if you can just say it up right now. I'm just relying on getting a copy of the recorded call here, and if you want to give any information for contact, you can lay it here, or I can just contact Roger maybe tomorrow.
I just gave it to you. It's Michael at afreecountry.com.
Oh, okay. Thank you. I thought you said you can contact me at the free country.
No, contact me through afreecountry.com.
Okay.
It is a free country, actually. You just have to know how to back that up. We know how to back it up.
I will do that.
You probably thought you were the rudest person in the world.
Thank you.
Okay, next question. Anyone else ask for the floor if you'd like to ask either questions about the common law court of record. Anybody else
we were
have
thorough.
any questions? Wow. Very well done. Okay.
Hey, I have a question.
Go ahead.
This is something very basic. In Florida, we have a common law law here, or statute, whatever you call it, wouldn't be statute. It's called tenancy by entirety. Here, like for example, if a husband and wife buy a house or claim anything under tenancy by entirety, the creditors of one cannot go against the creditors of a non-debtor spouse. They view the marriage as a single unit. Would that be deemed a person or under common law? Because it has been stated it is an old common law status.
Well, for starters, if there's a statute involved, it's not common law. There are no statutes in common law.
I may have misstated that. Please bear with me.
Okay.
But it's automatic. If you as a husband and wife own a home, it is automatically deemed tenants by entirety.
Well, I've never heard of tenants by entirety, and I used to sell real estate. for a living, so I really couldn't answer that.
I think the best way to do it, this is how I did it, this is Justice Tadlock, is to go through the statutes and then look at their definitions. Because in Colorado, everything is for persons. The borrower is a person. The grantor is a person. They're dealing with persons on all of it. And so what the best way to do it, and you can probably figure it out really quickly, is just to go to the statutes and see. And because they define it, and they'll either use person, and then they'll use the definitions, and they'll explain that a person is a corporation, everything else that we were saying, that it's not. So,
now just so you know, now this goes all the way back to the earliest Constitution when Florida was finally under British or American rule later on. It goes all the way back there.
Okay.
If I may.
Okay.
Yeah. Hold on just a second, though. Hold on just a second. On the person issue, remember, you will never find the term people used in any statute because they have no jurisdiction over people.
And Justice Hamilton, that's what I was going to say. I mean, you hit you hit the nail on the head to start with.
Yep.
If there is no, that's okay. If there's a person involved, then it is a statute or a code. It may be an old statute or a code, but it still does not refer to the people. So they're taking something old and trying to make it refer to the people. They can't do that.
Mm-hmm.
I yield.
Nope.
Something here that in Florida, if you have one person who is signed the mortgage and the note, but the other person has not, if both names are on the deed but not mortgage, then even if they default, they cannot take the house because of the tenants by entirety. In other words, they cannot deprive the non-debtor spouse of that property. And if the debtor spouse passes before the non-debtor spouse, they're, put it bluntly, SOL.
Well, they can't touch the property regardless. And that's what we've shown. All of this is done in fraud. All mortgages are done in fraud.
Right.
So remember that as well. I know you're still holding on to statutes and codes, but you got to separate yourself and act like the king that you are. I yield.
If you've called yourself a debtor, then you're using statutes, by the way. So you answered your own question.
And as I always say, if you're going to call yourself a sovereign, you need to act like one.
Right.
That means no fear.
Yep. Debtors
like
are
Tadlock. Tadlock has no fear.
I will have to say, this is Justice Doucette. I am so proud of the work that Justice Hamilton and Justice Tadlock are doing and how they're helping other people as well. And it's great people like them that are taking their time to focus on this stuff that really makes a difference for everybody. I wish I had the time to help everybody with what I've been tasked to do. I don't, but I am so grateful for both of you gentlemen. I yield.
Well, thank you, sir. I wish I had the time, too. There's too many people.
Yep, and we feel the same about you, Justice Doucette, just so you know.
We do, actually.
If I may?
Yes, go ahead.
I just wanted to add to that this is David in Michigan again. This is one of the most informative, high-level talks that I've witnessed in a long, long time, if not the best, and I wanted to thank everybody.
Well, you really have to thank Roger Dowdell for that. This was Roger's idea for tonight. I had other plans, but, Roger is a great leader, and yes, I definitely agree. It was something that needed to be done. And thank you, Roger.
You're welcome. I'd like to thank everybody for participating. That's how we all learn.
Right.
So, any more questions on the Common Law Code of Records, folks? Toasted, are you there?
Yes, I'm here.
Okay, Toasted, could you announce if someone wanted to listen to the playback of this recording, how would they go about doing that?
I think we lost Toasted for a minute.
No, sorry, I had to mute somebody out there. Too much background noise.
Okay.
It will be on YouTube, Revolution News and Information. I think the Judge Doucette, do you still want to name?
It's the Great Deception that is exiting the Matrix. And it should be today's date.
Yeah.
So anybody should be able to go to Revolution News and Information and look up the Great Deception, Exiting the Matrix with Judge Doucette and today's date, and you should be able to find this recording.
One more thing I'd like to mention. I'm going to unmute you, area code 941, ending in 95. Please mute out on your end. You're on the host line, so I kind of got to leave you unmuted. But if you could control your background noise, that'd be awesome. Thank you.
And Toasted, how long after the call before it's usually posted on YouTube?
It could take. Hold on a second. I'm not unmuting that number again. I'm tired of it. Anyway, it takes about, however long the call is about how long it takes to get on YouTube.
Got it. Very good. Thank you, sir.
I yield.
And Roger,
okay, last call.
Yes, Dick in Florida here. Could you once again please tell me where to go in order to hear the entire transcript of this call again?
It is Revolution News and Information, and that is on YouTube. And you're going to look for, I believe it's titled Exiting the Matrix, that is the Great Deception, or the Great Deception that is Exiting the Matrix. One of those two, but it should say with Judge Doucette. Go ahead, Roger.
Yeah, and the critical thing to put in your search of YouTube is today's date, 11/20/16, and that should bring it up.
Well, and don't get confused, because there is another Matrix call, I believe, that Revolution News does that was earlier, just before this call here. So you could get a little bit of confusion there. But if you look for, I think I'm fairly certain that all of the Matrix calls are titled with Judge Doucette. So if you look up, go to Revolution News and Information, and then type in Judge Doucette and then today's date, it should bring you to the correct call.
Judge, would you please spell your name? D-O-U, and that's D as in dog, O-U-C-E-T-T-E. Thank you so much.
You're welcome. And one more thing, hold on just a second. Anyone that has a problem finding this, I'm going to put my phone number out there. Feel free to call me, and we'll make sure we get you the correct link. My phone number is 720-338-0394. And I'll repeat that. Give everybody a chance to grab a pen. 720-338-0294. Okay, go ahead, sir.
Oh, yes, I just was hoping that maybe Roger can include the link to his normal email list, and that would be greatly appreciated, too.
Sure will.
Thank you, sir.
Okay, please, when you do ask for, please ask, may I, and then give us your first name and state so we know who you are, and then go ahead and talk. last call for questions on the Common Law Court of Records, which was the discussion for the first half of the call.
And if I can add something to that, now people, this Court of Records will work for any case, whether it's IRS, whether it's foreclosure, whether it's a traffic ticket. A Court of Records works for everything. So if you've got questions, now's your time to ask. I yield.
Okay, last call for questions. Yes, please identify yourself.
Yes, this is Heidi
Lady first.
From Florida. And I was told that someone was going to send me a sample of the wording, like a document. Excuse me, I apologize for that. The document that with the wording for the Court of Records, because I understand it's all in the documentation, correct?
We're having a hard time hearing you, ma'am. At least I am. Can you try to ask that question again and maybe adjust your mic or your volume on your phone, please?
Yeah, I had it on speakerphone.
There you go.
Okay. Now, I was asking, as far as the wording for the Court of Record, because I understand it is all in the documentation, is there a place we can go to for a template or a
And I will let Justice Hamilton answer that. And would you explain to people, Justice Hamilton, that for anyone that is a marshal or superior court judge, that the website is free, and for other people, what the fee and everything is, please?
Okay. We have a member forum on freecountry.com where we share our paperwork, and you can go see any of the cases that have been processed there. I was recently cut off from 2Checkout to process my credit cards because they said I'm giving legal advice on the site, which is against their terms of service. And they said they would not give me my money unless I filed an IRS form, so I'll be filing a claim against them instead in court, and it will cost them a lot more than the few $100s that they owe me. However, anybody who is a continental marshal, a continental judge, a grand jurist, or active duty military is considered a contributing member and gets free access to the member forum. Anybody who signs a contract with me to have me handle his or her case gets access to it, and anybody else who mails me $1 silver gets access to it. So I guess I'm going to have to go to the silver dollars since the Federal Reserve notes have been cut off, which I have a lot more faith in silver dollars anyway. I was charging $30 FRNs and or $1 silver, which is about 17 Federal Reserve notes today. So that's how much more faith I have in the.
That $1 silver is for how long, Justice Hamilton?
I've decided it's for indefinite. I was making it an annual fee, but I had everything automated, and the automation wasn't working, so everybody who was paying a dues got pretty much unlimited access anyway. So $1 silver gets you access, period.
And, for that site, people, there is no place else where you can find a way to beat these admiralty courts and this corruption that they're doing. I mean, you can spend any kind of money for any kind of attorney, and you're probably not going to be successful doing it. So for as little as $1 silver, there you go. You can come up with the answers, and we've proven that those actually work. One other comment that I would make is Revolution News and Information is kind enough to record all of these broadcasts for us. They not only do the judges' call, they do the marshals' call, they do the nationwide judges and grand jurors calls. They do all of the calls, and they're paying for all of the bandwidth and stuff out of their pocket. It's very important to keep all of this going and to get this information out to everybody for free. And so they can use your assistance in helping pay for that bandwidth. So anyone, even if you can only afford to donate $1 or $5, all of that very greatly counts. And please help. We're all trying to do our part, and we're all trying to fund this out of our own pockets. But, you know, especially with Revolution News and Information and all the shows that they're recording, that's a lot of bandwidth to pay for, and they can really use your help.
Yes, may I thank you so much for that, Judge. You said this is highly favored again. Brother Hamilton, do we mail, you said we send you a silver dollar. What is the correct location for that, or do you want to email that to us, or how do you
there's actually instructions on the site for where to mail it to. If you go to under the home menu, you'll see a link for member dues. Ignore everything about paying for the $30 and just follow the instructions for the addresses there where you mail it to. And when you mail it, I do recommend that you do it in some means where it can be tracked, since you are mailing a coin. And then you can email me a copy of the tracking number so I can know it gets there, because I'm out of town a lot and I commonly can't check the mail, so I wouldn't know when it got there without you notifying me. Okay?
Okay. All right. Thank you so much.
If I may.
You're very welcome.
If I may. This is
yes, please identify yourself.
This is Justice Tadlock again. And I spent $30 with Michael Hamilton, and it was the best $30 I have ever spent. I mean, he's worked. Any lawyer would have charged way more than that, and he's just getting 30% of whatever happens on the what we receive from Wells Fargo. But the $30 is well worth it, and I just want to tell you that, Michael. I mean, you've worked more than $30 on this case. That's all I got to say. So,
well, I plan on getting paid a lot more than that when you get paid, and we're going to use that to help a lot more people.
Yep.
Okay.
Oh, I'm sorry. If I may.
Go ahead, Judge Hamilton.
I forgot. There was something else, Judge, you said a minute ago about hiring attorneys. And I want to point out to everybody who considers hiring an attorney. There's some information that you can get on A Free Country. There's an article about why you should never hire an attorney, and it explains very specifically why. In the encyclopedia that attorneys use called Corpus Juris Secundum, it lists the duties of an attorney. An attorney's first duty is to the court, and that's to the inferior court. His second duty is to the public, and his third duty is to the client. And in this encyclopedia, you'll see any time that the attorney's third duty conflicts with the first duty takes precedence. So, and we've seen that in a number of cases where public defenders were assigned to somebody where they actively work against their client to protect the scam from the court. They do this all the time. You're also automatically consenting to the inferior court when you do that, so any rights that you want to protect are out the window. And finally, anybody who hires an attorney is considered a ward of the court. And a ward is defined as an infant or one of unsound mind, which is why you now see us add that phrase of sound mind in our first paragraph of our actions. And I yield.
Okay, I'd like to thank everyone for participating in this part of the call and hand it back to Justice Doucette unless there's any more questions.
And even if we have more questions throughout the call, people are willing. I mean, you can step up and ask those. But I would like to, forward what Justice Hamilton said, that I'm sorry, but anybody that hires a lawyer is an idiot. And you're proving you're an idiot. Mm-hmm. And I don't mean to be rude with that. I'm just being honest.
That's what they said.
There is no.
They said you're an idiot.
There's no
Can I ask
need
a question?
to put your well-being in these courts' hands. Yes, sir. Go ahead with your question.
I'm wondering how I'd like to get a report on the Wells Fargo thing that was supposed to something on like last Friday or Thursday was supposed to be happening. I missed the first part of the call.
Okay, that paperwork will be filed on Monday. And Justice Tadlock, would you update him on what you're doing with that again since he missed this, please?
Yes, and if it's still okay, I may come down there tonight to get it filed so I don't have to do it tomorrow.
You're quite all right. Yes.
Okay. So what we're going to do is we are going to file the writ of execution that orders the sheriff to foreclose on Wells Fargo's property that we have secured with a common law lien.
So they've actually secured Wells Fargo's banks that they're now going to foreclose on. Since Wells Fargo was trying to foreclose on his house, it's only fitting.
Right? They fell into their own snare.
There you go. Beat them at their own game, people.
Right.
Yeah,
well, that's important because it's a scam anyway. I mean, it's a scam. They don't own a debt. They got paid. So the whole thing is a scam just to steal your house anyway.
Yeah, and remember, we're the ones that are doing this honorably, not them.
Mm-hmm. That's
so
right.
We are beating them with their own snare, and we're actually doing it honorably.
I love it.
Yeah.
Any plans?
Does that answer your question, sir?
I'd like to know if you've got any plans what you're going to do with the properties. Maybe like start like a farmer's market or like a goat barn or something in there, maybe.
The people need their own banks. We need lawful banks. So I think Justice Hamilton and Justice Tadlock will probably end up making some good money by opening some honest banks for people. But anyway.
I think Justice Tadlock plans on getting the cash.
Getting the cash first, though. I mean, that's for sure.
Yeah.
Getting the cash first.
Sell them to another bank.
Yep. But there's a lot of
plenty of banks to take it. Exactly. And there's lots of fraud being perpetrated. Sorry.
Before anybody makes a comment, please ask for the floor. Even if you're part of the conversation, I know I don't always do that, but I'm the moderator, so I get to step in here anytime. So, sir, did you have another question, or did we answer your question?
No, I yield. Thank you.
Okay. All right. Thank you. Okay. Yes, sir.
It's all yours.
Thank you, Roger. So, again, I've already stated that if anybody has more questions, I believe Justice Hamilton and Justice Tadlock will stick around, so they'll be happy to answer questions for you. But as you can see, people, it is taking us years to come up with all of the information to do this. Now, I want to give credit to Bill Thornton. I mean, he has done great work for years, but Justice Hamilton and Justice Tadlock have taken what he's done to the next level. And now we can be successful all of the time with our cases and always be honorable. Whether the judges we're dealing with or not are going to be honorable. Now, on to the second topic for tonight. And I know that this is going to upset people, and I'm not here to upset people. I'm here to try to save souls. I see that as part of my calling is to help expose the corruption that is the Matrix, that is Babylon, and to make sure that everybody gets out of Babylon and stays out of Babylon. And in doing so, I hope that it saves your soul. One of the things that I have run across that, just like with the government scam and everything else, when you first discover this stuff, it kind of pisses you off. So I understand that by me saying these things, it's going to piss people off. Don't shoot the messenger. I am here trying to share truth with you that I'm finding. I'm not saying that this is the end-all and be-all of the truth, but I'm saying that there is proof from the Bible itself that who we think we're worshiping is the beast. We think that Yahweh or Jehovah is God. And if you go back, and I'm going to challenge everybody to do this, don't just take my word and don't just argue with me to start with. Go do this yourself first. And then come back and let's have a discussion about it, because this is not about me trying to prove that I'm right. This is about all of us trying to come together and find the truth. And some of the things that I now have been sitting on for a while that I believe now, some of this research I feel like I'm through and I found the truth on it. There are other parts that I'm still researching. I mean, Roger can tell you I spent all day researching this, and I spent all last night doing this, and I continue. I've been doing this for a couple of years now. But if we take the Bible itself and we go back, and you can get Bibles out there that will give you the numbers of the words, and then they will give you the true Hebrew meanings of those words. Well, if you go back and you start taking these words and you look at the alternative meanings for those words and start putting things together, the Bible paints a totally different picture than what we think it does. The whole forbidden fruit that we thought that was in Genesis, instead of it being a forbidden fruit, it may very well be a hologram. It may be, instead of being the tree, it's actually a rod. And that rod is what allows the serpent to deceive the people. And the very people that we think are Yahweh or Jehovah are actually the fallen angels, and that we're being deceived with this. And so what I would ask is people, don't be angry with this. This should be a discussion that we're all trying to find the truth. Go and look at the alternative meanings. Go through Genesis. Go through Matthew. Go through Hosea. Even in Hosea, Jesus Christ is trying to explain to us the deception and tells us that Yahweh is the beast. And we're not seeing those things. We know that there have been several lords and gods in the Bible, and that all of that was confusing. Well, I'm going to give you guys all a starting point for somebody that has been doing this research for many years. And I don't agree with everything that she says. Like, one of the things that she says in Genesis is that she believes that the Elohim, which in the first chapter of Genesis, God is actually pronounced as Elohim, or the benevolence that created this earth were called the Elohim, which is who we call God. Now, it wasn't until the second chapter in Genesis, and I think it was the second chapter, verse 4, that Yahweh was introduced. So anyway, what I would all like you to do is there is a, and let me look this up so I give you exactly the correct information, but I believe it's 9Ninja is how you pronounce it on YouTube. And hold on just a minute, and I'll give you the spelling on that. So bear with me just a second here. And, of course, because I'm trying to give this all to you, the computer is going to be slow. Okay, it is the number 9, and then it is Nania on YouTube. Or she has a website that I believe is indigoflower.com. You can go there as well. I have been following this girl and her research for a couple of years now. And I will have to tell you, I had times when I would follow and I would say, no, she can't be right, and I'm not going to listen to this anymore. And then I would find something else in my studies or my researches where I had questions, and then I would go back and find out that she had the correct answer all along, and I just didn't want to hear it. This show on exiting the matrix and exposing the great deception is all about us getting to the truth. So if we believe that we are worshiping our Heavenly Father and we find out that we're not worshiping our Heavenly Father, but we're actually worshiping the beast, do we not all want to know that? And do we not all want to make sure that we are praying to the correct God? Now, with that being said, I'm going to open the can of worms up for questions and comments. Am I still on?
Yeah.
It went dead silent, so, I don't know if people have got their guns out just ready to execute me or not, but...
If I may ask a question, can you elaborate on what you're...
Yes.
Can you elaborate on what that YouTube is just about, like in 30, 50 words or less?
I'll try to.
That you're,
what this lady has done, and I do have a lot of respect for her. This lady is not doesn't belong to any religion. She is very logical in her thinking, and it's all about her getting to the truth. And I will have to tell you, when I first started listening to the Genesis thing, it was almost like, oh my God, here goes the alien agenda or something like that she's trying to put out. But you have to bear through some of that thing and listen to it all and use your deception. I will tell you, this girl does believe in Heavenly Father and does believe in Jesus Christ and that He is there to save us all. And she is trying to take everything from the Bible and tie it in with what is happening in today's time, right now, and figure out exactly where we're at. And I have been doing this same thing for many years. And so I have actually looked at her research and a bunch of other research and done research on my own. And I find her to be extremely correct with how she's doing it. She does everything in a very logical manner. I may not agree with everything, but I think she's fairly close to having this nailed. And she's not trying to preach. She's trying to point out the alternative meanings. And she's taking word by word the Bible, Genesis, Matthew, all of the different scriptures, and going back and translating every word in that scripture back to the original Hebrew meaning. And when you do that, the Bible says something different than what we're told it does. So, did that answer your question, sir?
No. What are the facts that that was just general saying that you think she's right, but what she's saying, what is she saying that you think? The main facts. And I would also like to know if she thought when the serpent attempted Eve in the garden, if that in Hebrew is that let's say it's an upright standing serpent, a very intelligent serpent. I'm wondering if that wasn't like a reptile alien.
I believe that serpent is actually the fallen angels.
Yeah.
In
talking
my opinion,
about like the reptile aliens,
the
reptile type aliens.
Yes. I believe from, how it translates. This is not her opinion. This is mine listening to the different translations. And she doesn't just give the one translation and say that that's it. She tries all of the different translations or meanings for each word in Hebrew to try to figure out what it's saying. We read the Bible and we take the meaning for the word that they gave us is what we think it is, instead of taking that word and looking at the alternative Hebrew meanings for that word. So I don't know if I'm answering your question. I'm trying to.
Well, I thought you could get a little bit more specific.
Okay. She has done this not with just Genesis, but the whole Bible. She's gone through the whole thing. So you have to go back to her work several years and try to do this with all of the scriptures. And when you start looking at them that way and knowing what time we're in and what's happening right now, the alternative meanings actually mean more than what we were told. What we were told becomes very confusing, but when you look at these alternative meanings for it, it's not confusing anymore. It takes a lot of the confusion out of the Bible, especially the Old Testament. So, but I will tell you, there are things in there that are going to really upset people, because we're going to think that things were one way, and when we find out they're really another way, it's going to be just like, finding out that we thought the government was for us and to protect us, and then finding out that it's totally the opposite. These evil ones have tried to deceive us in every way and everything and every part of our lives. And it's all about trying to get our souls. Whether you people believe that or not, I believe with all my heart that is what all of this is about. They're after your very soul. Any other questions or comments, please? You may.
Yes. What was that YouTube channel you were saying? Trying to get it, but I didn't get it in.
Hopefully, I still have it up. It is 9, and this is the number 9. It's not spelled out. 9, N-A-N-I-A, and it's on YouTube. And then I believe she has a website that is indigoflower.com or net. I'm not sure, but if you go to the YouTube stuff on her videos, it'll have the website address as well. And so I would like for everybody to go and start a quest of retranslating the scriptures using the alternative meanings for these words themselves, and come back and share with people what you find. Because this is about all of us trying to find the truth together and sharing that with one another and discussing that. Do I have any other comments?
So that was 9, I-N-A-N?
The number 9 and N-I-N-I-A.
Hello?
This is Cheryl Dean, may I?
It's N-A-N-I-A.
Yeah, 9-N-A-N-I-A. You're correct. I'm sorry.
That's right.
Thank you for the correction. And Cheryl Dean, what did you need here?
I really couldn't understand. Y'all were talking over each other. One at a time.
Okay. The number 9, okay? So it's not spelled out. It is the number 9, and then it's N-A-N-I-A. and that's on YouTube. Should be able to just do a search for that and find her channel. And I believe if you go to her playlist, you could start with the one on the Bible and stuff, and it'll take you a while to go through that because she's done a lot of research. She lays everything out, but it'll be an eye-opener for you. And then go back and check her work and do it yourself. That's what I've done to see, okay, well, maybe this means something else, or maybe it should be this word instead, and how would that make more sense? And so I've done that, and I can't find where she's wrong. So I would like everybody else's help.
If I may.
You may.
Real quick, if anybody has comments or questions, please hit star on the keypad, and I yield.
Thank you, Toasted. So if anyone wants to ask comments or questions, hit star. And Cheryl Dean, you're up here. Go ahead.
Okay, thank you. I just wanted to make a comment that a friend of mine and I were talking about this just this afternoon, about the credibility of the scriptures and the words and going into what they mean.
Had you seen my post on Facebook, or did you just happen to do this out of the blue? Oh, well,
wow. I don't do Facebook.
Wow.
And so I just wanted to throw that in. And this is just blowing me away, this whole thing, because we were talking about this and something about the qualifications of an elder, and I says, well, I don't know that I go along with everything Peter says. And some of the stuff we were questioning, and it was on the same theme as what you're talking about here now. This just blows my mind, kind of. So I just wanted to throw that out there.
And I will tell you, though, Geraldine, it's kind of cool when you do this, because Jesus Christ and everything that Yeshua HaMashiach, because that's still his name, Yeshua, when he was here, was in his teaching, he was trying to expose the fact that who these guys were worshiping as God were not God. They were the beast. And that's why they ended up killing him. And he was trying to tell everybody that, and we weren't getting it. And, we're in the end times. We're in the end times. I'm sorry, I don't want to be them. I want to get it. And I want to be right. I don't want to be crucifying my Savior.
Well, and how the deception has come into the church and the counterfeit. That's one of the things we were talking about, the counterfeit that's in the church.
Well, and even people that
all
we
of this
thought
you were talking about.
Even people that we thought were prophets in the Old Testament and stuff, it turns out that they're not really prophets. And again, Yeshua was trying to expose that and show it to us. But when you use the alternative meanings, it hides what Yeshua was trying to tell us. When you go in and you read what really he was trying to say, which is what we're being given as the alternative meanings to these words, it says it plain and clear. It exposes it. So, if any of you don't have the time to put a couple, I think this girl's been at it for 4 or 5 years. If you don't have the time to put that kind of work in it, and I don't even have the time to put as much work into it as she has because I have so many other things going on, I would encourage you to go listen to her stuff and pray about it. The Spirit is going to give you eyes to see and ears to hear. So,
if I may,
you may.
Yield. Thank you.
I wonder if this is limited to this subject, or can one discuss another subject?
We're trying to stay to this subject, unless you've got questions on the Court of Records that we did earlier. But I try to keep.
I do have a. It's related. I'd like to know what a little bit of background of the procedure to establish when you go into court what is said, what is required to say, or is it just a document that is submitted? And,
a court of records should be your paperwork. It's not what you say in court. Justice Hamilton, are you still on? Would you like to answer that, please?
Yeah. Yes. You have to remember, when you go into court, a judge is well trained at debate in court, and you may not be. So anytime you go into court, and you have to remember also that sometimes judges will try to deceive you into arguing your case orally in court, because if you argue orally in court, he can disregard your paperwork where you just smoked him. So when you go into court, a judge tries to get you to argue, refer him back to your paperwork. I've said everything I need to say in my paperwork. I don't know how to make it any clearer than what's in my paperwork. Always refer back to the paperwork. It's written very simply. Go ahead.
What was it called, the procedure? At the same time, you do it the same day that the document is submitted, or is it a motion, or what, to remand, or to, what do you call it, back to put a stay of the process in the other court so they can't move forward? What is that called when you, as soon as you do the counterclaim, you stop the other case from moving forward? What is that called?
Well, for starters, when you file, if you're being challenged in an inferior court, that court should be one of your named defendants. So this court's going to be served anyway. The judge in that case should be a named defendant, because the judge is proceeding against you without proving. Remember, your claim is all about challenging jurisdiction, and a judge, by case law, may not assume jurisdiction by deciding it. Case law even says if he proceeds without proving jurisdiction or without jurisdiction, he proceeds at his own peril. So you'll hear a lot of attorneys and a lot of judges and attorneys will claim that judges are immune, and they'll quote some statute that says in carrying out their official duties. But what you have to remember is when that judge exceeds his jurisdiction, he is no longer carrying out his official duties. He is attacking you like any other individual that is trespassing on you. He's causing a trespass, which is an injury caused with violence or the threat of violence. I yield.
May I ask another question in that regard?
Yeah, go ahead.
As soon as a judge, any judge, says the words "I have jurisdiction," he's practicing law from the bench right there, isn't he? Because it's the accusers, isn't it not the accuser's job, function, and responsibility to prove jurisdiction? As soon as a judge says anything about "I have" or "there is jurisdiction here," how can he do that if the accuser has not proven jurisdiction?
Here's what my response would be if I were standing before that judge. Okay, judge, since you do not have a legal authority or a lawful authority to decide that, then you'll have no problem proving that on the record as required by law. Okay, judge, then you'll have no problem proving that on the record, because by simply deciding it, you're committing treason.
All right, but you can't object.
Look, we've got
you can't object at that point because. May I ask, when you get to that point, how do you deal with it? Normally, in a normal court case, you have to get objections on to go to the appeal.
Oh,
so you have to have an objection on it. But if you object, aren't you granting jurisdiction to them by objecting? How do you put it on the record that you disagree?
That's a bunch. Well, for starters, you're going to make a defendant out of the judge.
Yeah, you got to start. I think I can answer this, Justice Hamilton. But, when you get a ticket, you don't just go into court and try to enter it there. The minute you get that ticket, you have to file a counterclaim in the Court of Records and claim that and submit that paperwork right there. And then when you get into court, you don't say a thing. You say, it's all in my paperwork. And you stand on your paperwork. And therefore, if you're not skilled at law like Justice Hamilton and I are, then you just stand on that and he can't trick you. Otherwise, he is a master at deception. he is going to trick you into giving him jurisdiction. Now, if you yield and give him jurisdiction, then he has jurisdiction. Don't do that. So you simply say, it's all in my paperwork, I stand on it, I have nothing else to say. Whatever he tries to do, you can object to it if you want, but all you do is when the case is finished, you go back and whatever ruling that he did, you go back and reprimand that judge for making a ruling in a court of records because it's your court. You are the judge. He has no right to make a ruling.
May I ask another question? Is there by any chance a few choice, juicy orders or whatever that you should commit already pre-printed there, or when you deny their orders and you reverse their any of their orders? Is there? I would suggest there'd be like a little packet of them.
Okay, Justice Hamilton has those on. Okay, you got to stop interrupting me now. Okay?
I'm sorry. Go ahead.
Justice Hamilton has those on his website. And Justice Hamilton, would you give that out again, please?
AFreeCountry.com.
So there's templates there on how to do a counterclaim. Remember, it's not a countersuit. We don't sue. We claim.
That's right.
And all of that is right there. You just follow that. Okay? So I hope that answers your question. I don't want to get into a lot of confusion for other people. If you don't understand something, please go to his website and look it up there.
In part, it does. Oh. But the other question that I asked was not answered, and that is, what is it? The term called when you go in and you by your order, you stop the process, you stop the procedure until your claim runs its course. What is that called? When you the term the process called when you stop all?
It is a counterclaim, and that was answered. All of that is on the website.
Are you referring to notifying the inferior court? Is that what you're referring to? You file your court in the court of record. Are you referring to the inferior court? Okay. You're going to notice the court. You're going to notice the court that there has been a claim filed against them. You can also do a notice of removal, removing the case in their court to the superior court. And I usually recommend going to the federal court because the federal courts tend to be more honorable than the inferior courts. And they've usually caused enough damage to you by attacking repeatedly to support that anyway.
That's the word.
You would be doing notice of removal. Yes, and you file that in the inferior court, not in your court. What you essentially do is you file your counterclaim in your court of record. I recommend federal court, and then you're going to send a copy of that along with a notice of removal to the inferior court to notify them that a superior court is now handling that case. That's how you would do that.
Also, let's say you're running a little late and behind on your counterclaim. Is it possible to put a counterclaim in that might not be totally complete and amend it so you could just, once you get it established and everything kind of stopped and you get the notice of removal in, and then you could maybe put an amended claim in?
Well, let's think about what you're asking. If you open a court of record, who's the tribunal? You are. So later you're going to move the court. You're going to submit a motion to the court to amend your counterclaim, and then you're going to grant permission. You're going to grant permission to you to do that.
There you go.
Oh. Okay, so that is definitely. I mean, you don't have to have. If you're running late and you need to get this in, just to get it in timely, you could do that, and then get the basics. Just get some basics in, and then just get all the polished, everything else polished up, and in what do you call it? When you upgrade it?
It's called an amended action. You're going to do an amended action.
Okay, amended action.
Mm-hmm.
Okay.
But remember, you have to submit all, in common law, you have to submit all of your evidence up front. So you do want to have your list of exhibits correct.
Now,
Phyllis,
as
can I
well
make a
as
quick comment?
you're decreeing your loss, and you want to have that in your initial complaint.
And we have a file called the law of the case that we submit as an exhibit that's up to 12 or 13 pages now. We'll work every time we find something useful, we add it. It doesn't matter what the case is about. We decree all of that to be our law.
What else goes in addition to the law of the case?
Well, the exhibits,
So
like any citations. Yeah, if you're filing a counterclaim, remember, when you file a counterclaim, it's based on jurisdiction. They gave you a citation and arrested you. That is a trespass. You got two different. I think there's, if I remember correctly from Bill Thornton's lectures, there's typically 5 different injuries that can be caused, but primarily there's only 2 that we ever use as trespass and trespass on the case. Trespass on the case is fraud. A trespass is an injury with violence or the threat of violence. And any time that government is involved, that's considered trespass, because it's always a threat of violence that they're going to come against you with guys with guns and lock you up. That's a threat of violence.
You hear how they formatting this stuff? Oh, okay.
Fellas, can I ask a quick question?
You can.
I just want to make a comment. I was just listening tonight. I've never actually been on the call before, but one of the things that caught my attention when the gentleman before said, what's a normal case? And I just think we need to be reminded that there's nothing normal about these courts. There's 12 different ways they're committing fraud against us from the start.
Mm-hmm.
There's nothing normal. And I liked what the other gentleman said. It was the understatement of the year when he said that the judges are highly trained in debate. They're more than highly trained. Most people that go in there don't have a prayer. If they want to put you in jail, they're going to put you in jail. You better know what's going on. So my point is, we could shut this whole court system down overnight if we just stop going there. That's what we need to do. We need to just notice
if
them.
I can make a comment.
Let me just finish. Now you can say whatever you want to say. First thing you got to say is I invoke, and in your paperwork now. In your paperwork, the first thing, I invoke the laws for the Republic under Yahweh's law alone, because that's the law. It's a royal common law. That's the law. There is no other law. Second thing you got to do is stay out of their courts, and we'd shut this country down tomorrow. Now, I've spoken my piece. Go ahead.
Okay. Well, there is something normal about every case, and that is that they're trying to take jurisdiction where they have none. And so that is the common thing and the normal thing, and that's why Justice Hamilton was saying the first thing that we always challenge is jurisdiction, because they're always assuming that they have jurisdiction, and in a court of records, if we're using a court of records, we know they don't have it. With that, I'll yield.
Well, no, wait a minute. They kind of do have it, and the reason that they do have it is because we don't say, I invoke the laws for the Republic under Yahweh alone. They do have it. All they're doing is they're making a claim, and nobody is challenging that claim. So they got a claim, and we got none. Now, if you go in there and you put in your paperwork, excuse me, I don't mean go in there. If you put the first thing on your paperwork says you invoke the laws of the Republic, now you have a claim. Now you're saying, hey, look, we're not playing by military code anymore. We're playing by the common royal law here.
And I don't disagree with that. But when you're invoking a court of records, that's what you're doing. Go ahead, Justice Hamilton.
Exactly. There's two things there. Well, I tell people all the time, when we go into court, your purpose in court is to convince everybody else who's looking at your case that you're normal. And that means you don't go into court invoking things that normal people don't do. there's other ways to do that. For example, I, Michael Hamilton, or comes now Michael Hamilton, a people of sound mind of Kentucky, in this court of record. Here's what I did. I specifically said, I'm a people. That makes me sovereign. I identified which people I am by my name. I don't have to say of the family Hamilton, because everybody who normally hears somebody say Michael Hamilton knows that Hamilton's my family name. I don't have to make myself sound weird by saying of the family Hamilton. I do not invoke anybody else's law, because when I said it's a court of record, I specifically said it proceeds according to common law, which took away their jurisdiction. I don't go in there and say things that make me look kooky to all the normal people in the galley seeing the case, because I want them to take my case seriously. And I do go into the court, because when I file my action in a court of record, that's my court. Stepping into it doesn't give up anything. I have not done anything like what you're suggesting in a single case, and not one single case has ever been lost.
And I'm going to stick with Justice Hamilton on that. I hear the comment that you're making, sir, but I'm going to disagree with the fact of how you're going about it. You should put everything into your paperwork and just stand on your paperwork. And you do.
Okay, wait a minute now.
It is
guys.
a court. No, hold on. You're interrupting me now. A court, the whole purpose of a court is to convince the people that you are right, not that you are abnormal. So, and that's the reason.
Yes, but you're making an assumption. You're making an assumption.
Wait a minute. Don't step on me now. If you step on me, I'm going to have the host mute you out. Okay?
Yeah, but I want to correct something. You're saying something I didn't say. You guys both said that I said to go into court, and I said specifically, don't go into court.
And we're telling you you're wrong by doing that.
Right.
I said to put in your paperwork, and however you want to word it, sir. If you want to say I'm one of the people, that's fine. Comes one of the people, hey, that's wonderful. But I just want to make the point. I said put in your paperwork and stay out of their court, because that's how we're going to take our country down.
Okay, now if you're referring to staying out of their court as opening your own court with your paperwork, I agree. If you're saying don't physically walk into the court, they're going to send guys with guns and lock you up.
Yeah.
Or make decisions without your presence. And there's a lot of things that tell people all the time, no matter how legitimate you're saying, or whatever what you're saying, how legitimate what you're saying is, we still have to appear normal to all of the people that we want to enforce our orders.
Yeah.
I yield.
Okay. Anyway, do we have any other questions about court of records, or you may go ahead.
I'm wondering. Gosh, what was I going to say about the? I yield. I'll step back. I can't remember.
If you remember it later. I do that too, sir. So don't feel bad. I'll start to say something and go, oh my God, I'm old. What was I trying to say? So if you remember it, sir, just ask for the floor again, please.
Yes, ma'am.
Do we have? You may, ma'am. Go ahead.
Okay. This is Harry Favorite chiming in from Jacksonville, Florida, once again. And
you need to speak into your phone a little more, dear. You're
okay,
down
yeah,
low. We can't hear you.
I apologize. I was talking through speakerphone, but okay. I took it off the speakerphone. But this is Highly Favorite once again from Jacksonville, Florida, and back in 2014 we formed the Florida Common Law Grand Jury, and since that time have been attacked with federal and state-sponsored terrorism without bogus arrests and fictitious charges and so on and so forth. But we've had fraudulent trials and all of this and that. The district court here and the state court are in a conspiracy and working in concert to profit from the mobster style retaliation and vindictive prosecution. I just wanted to point out a couple of things because I and my son, we did go through some fraudulent trials or whatever, just on the knowledge that we had at the time. And Chief Paul Murray helped us. Anthony Williams helped us as well. Anthony's sitting in jail right now because of some fraudulent, fictitious charges. But I just wanted to point out that everybody needs to know that these people are practicing sorcery. They do demonic rituals and try to create an atmosphere and an energy of control where they want to lower your vibrations and your frequency so that it is all oriented from fear and in which they can control you and keep you in those lower vibrations. That's one thing to keep in mind whenever you're going into their courts. And then the next thing I wanted to point out is that anything that they do is fraud. You know, they're private for-profit corporations. They're DBAs. They're trading on the global markets. You know, when I went through the situation with the fraudulent trial, I put on record my documents, establishing what I know now to be the court of record, and demanding a forensic accounting of the case. Because I know that the case is being traded on the stock market. All it is, they're just administering trust law based on the birth certificate, and all the court cases is just a security that they're monetizing that security, and they're just using your name and your birth certificate, trust, and all of this and that's based on that fiat currency, so that they can profit off of it. And so, self-representing sui juris, as I was, and I got to put a lot of stuff on the record. And, of course, the judge, being the thug that she is here in Jacksonville, Florida, she just struck down anything that I asked for. But, like her oath of office, a delegation of authority order, all this and that, I told them about the crimes that were committed against myself and my son, which the U.S. Marshals beat up my son. That is on record, on video at the district court. I was molested by a United States Marshal. That is on record and video at the United States District Court. And so the judge in open court, she denied that the United States was a federal corporation per 28 U.S.C. 3002, fit section 15 and 16.
If I may ask what your question was.
Well, what my question is that the case went to appeal, and on the appeal, I got the certificate of interested person. On the certificate of interested person, it showed that all of the attorneys, including the prosecutor, all of the judges, are listed on there as profiting from the case. The only one that's on the case that is not profiting from the case is my estate, the name that these charges were bought in. So it's not really a question. It's just me pointing out different things.
And
if I may,
hold on just a minute. You know how to handle that now, though, because it sounds like you were still playing in their courts, and you got to take it out of their courts, and you got to move it to a court of records. Now, one other comment that I wanted to make is, the magic and the demonic stuff that you were mentioning that they do in these courts, that is exactly correct. And there are courts in Colorado here now that I have stood up and challenged the judge, and they won't even allow me in those courts anymore because they know who I am and that I stand with Heavenly Father, and they can't defeat that. And so, one court that I was helping Justice Curry's wife on in Montrose, Colorado, I stood up and challenged the judge and stuff. Well, I went in a couple months later. Now, mind you, I don't live in Montrose. I live 8 hours away from there. And so I went back down to help with something else on her case, and I was just going to file something with the court in her case, and I was met at the door. I mean, before I even got to the door, there was a sheriff there saying, Bruce, you're not allowed in this court anymore. And it's because they can't control me with their magic and their demon crap. And so, they don't even want my energy in their courts. Anyway, with that, I'll yield.
if I may.
Okay, so why would you go into their courts? You just said, why would you even go in?
Excuse me, I said if I may first. Excuse me, sir. I said if I may first in response to the lady.
Justice Hamilton, go ahead, sir.
Okay. Ma'am, what's your name in Florida again?
Highly
Ma'am?
favored. Yes.
Okay.
Highly favored.
Look, and it sounds like you knew a little bit that you intended to proceed in a court of record. The problem is you didn't proceed in a court of record. In your court, you don't ask the judge anything. You tell the judge. As a matter of fact, you can submit an order to the judge ordering him to produce his oath and his bond. But you don't ask the judge, because if you're asking the judge, you're not proceeding according to common law, because the judge is not allowed to make decisions in your court. That was the mistake you made, was letting the judge make decisions. And I yield.
How do you go about doing that? What's the term? What's the verbal directive you give to the judge, for instance? Can you give a couple examples?
Well, typically, almost every case we've been involved in involved at least one writ of error. And if we get, what we typically do when it comes to where we're ordering a judge to produce his oath and his bond is if he has repeatedly tried to take control of the court that he wasn't allowed to take control of. That makes him a criminal. And that's when we start demanding, that's when we order him to produce his bond and his oath. And you can do that in a writ of error. You can do it in a contempt of court order. You can hold him in contempt, and in the same thing, you can order whatever you want in your orders, whether you do a writ of error or an order to cease and desist or a temporary restraining order or a contempt of court order. Any of those, you can order the judge to produce his bond and his oath.
Remember, it's your court. It's not his court. So your paperwork doesn't have to look like their paperwork in their courts or any of that. You can do it any way you want. It's your court. The only one that has to accept your rulings and how you put paperwork in is you.
Exactly.
If I may, I don't know about, you said something about you can issue. I'm not interested in the things you can do. I'm interested in all the things that one might need to do. What is the entire list of every issue, a writ of error is one. What are all the things that are possible? What's the options?
And sir, it would take us forever to answer all of those questions.
Where do you find them out? If you need to use them tomorrow.
We have already told you that. freecountry.com has all of that stuff on there. It's amazing. It's set up for common law cases, and it will give you all of the information that you need.
And secondly, I remember the question I had. When you go, of course, you go into these magisterial courts. They're all inferior courts. Incidentally, did anybody ever find that ruling from the federal judge that made the ruling about a month and a half ago, saying that all these magisterial courts are operating illegally, and that anybody that's damaged by them, they could be held liable? Did anybody ever track that down? And my other question was, how do you determine? Of course, the really inferior courts, like magistrates' courts, they're all not court of record. But when you go into the higher court in your local county, the big courthouse, and they have court reporters and everything there, Bill Thornton says they're still not a court of record.
They're not.
Yeah,
of course
not. They're a court of record. They seem like they're a court of record, but what actually determines if they're a court of record? I yield.
I'll tell you. A court of record proceeds according to common law, and the duties of the magistrate are independent of that of the tribunal. Every single court, no matter how big the building is, no matter how many superiors they put in the title, that uses statutes is an inferior court. Every single court. If they are quoting statutes, they're trying to hold you accountable by statutes, by code, they're inferior courts.
And
courts of record don't have statutes and codes.
Right. And if I may, sir, you need to change your thinking. Okay? You seem to be trying to figure out how to function in their court system. but you are the king. In a court of records, it's your court. And so you got to change your thinking. You are the king. You can order anything in your court of records, and they have to obey because they are truly the public servants.
You misunderstood me, sir. That's not what I'm saying. Don't want to be in their court. I'm saying when you're in the arena and it's time to do what you need to do, I'm wondering what's the list of all the options, and is there a list of like that you could type out like 25 different types of orders that you could bring in with you and have them all ready to go?
But see, you again, your thinking is wrong. Okay, you're the king. You have to decide what you want to do before you go in there and have that on paper. That's it. You get to decide whatever you want to do. You get to control that case into any direction that you want it to. So you're still not changing your thinking to the fact that you're the king.
No,
you can write this stuff up.
I understand the options. I have to find all the options.
If I may.
Hold on.
I think I understand the question.
And I do too, but I'll let you go in just a second, Justice Hamilton. You know, you can write this stuff up any way you want. You know, just because we have templates for some of this stuff doesn't mean that you have to do it that way. Okay? You can simply go in there and say, I'm the king, this is what I want. I don't care what you want. Now, that's not necessarily going to work in a public opinion for other people trying to look on. But the point I'm trying to make here is that it is your court. Go ahead, Justice Hamilton.
It sounds like, Stephen, that you're looking for a cookie-cutter list, and there is none because every case is different. You might go into a court where your opposition submits a motion to dismiss because the state has sovereign immunity, and if you get your denial order in before the judge does, you just deny the motion because they're commonly going to come in there citing in their motion statutes, and statutes are foreign to this court, so you just do the motion. If the judge grants their motion before you get your order in, then you're going to do a writ of error correcting the court. A writ of error is how a court corrects itself. And since the court is by definition the person and technically suite of the sovereign, then the court, being you and your person and your suit, are going to correct the clerk for having accepted an order from the magistrate not authorized to make orders. So you don't always know exactly what's going to happen in court. And after the writ of error, that judge may become very honorable because you gave him all the lessons in law. And that's why I recommend that you use one of the cases for the writ of error that we have, because it includes all of the case law that teaches the judge why he's not allowed to make an order, including statutes and case law that says a judge that proceeds without jurisdiction commits a treason. So we can't just say, do this, do this. Well, the law of the case is what you decree when you file your action. The law of the case is go ahead.
What I'm trying to say is, like, you're going into a fight. Okay, it's logical that you would want to know. You want to know if you're going to give them a jab, right hook, uppercut,
right.
Leg shot. You know what you're going to do.
You don't know. You don't know until he throws a punch. You don't know if you're going to throw a left hook or a right jab.
If one doesn't know, what I'm asking is, if one is not familiar with all the possibilities and the options, one has to learn those options. Where are they? At what part of the website are they? The list of all the possible orders that could be made.
There is no list. We basically. Usually what we do is we just stay on the offensive. If they try to have our order strike, we just deny the order or deny the motion. But you have to remember that it's your court. Pardon me?
Just keep denying the orders and their motions. That's it. Order your order is denied. Your motion is denied.
That's right. That's exactly.
Get it on the record.
That's right. And eventually you're going to put your order in because they still have a deadline that they have to meet before your judgment goes in. And you don't have to allow the time to be extended because they asked for the case to be dismissed. They submit a motion to dismiss, and they don't bother or overcoming the arguments, the accusations that you put in your counterclaim or your claim. Well, day 21, guess what? Now the judgment goes in. So you don't let this stuff. That's why common law is so much better than the statutory system. Statutory system, these cases can drag on for years.
So
in Tadlock's case, we've been in 4 courts in Tadlock's case, won every one of them, and it's been about 11 months.
If I may, if one, let's say, 4 weeks ago, sent them a document saying that you're demanding jurisdiction is challenged, you're demanding to know this within 21 days. And the 21 days it has expired. What is the proper, give them a notice, or is this just part of it? You write it in your counterclaim that the 21 days has expired?
You issue a judgment in your case. It's done.
What happens if you didn't start the counterclaim yet? I'm saying that if the counterclaim has not started yet. You can't.
Nothing counts until you file a counterclaim. You file a counterclaim, they got 20 days to reply.
If I may.
Well done.
I yield. Thank you.
I yield.
Go ahead, Tadlock.
Yes. Just want to add on to what Justice Hamilton was saying. It seems as if Stephen, I believe, is stuck in the court, their statutory court, and he's right. There is a fight. There is a fight in there, and you're going to lose that fight unless you know how to debate, as someone has said before. And so you're going to want to get out of there as soon as possible. So he's going to try. Say he says, "Sit down, do this," and orders you to do something. You say calmly, by what authority are you asking me to do this? By what authority, by what authority, by what authority? And that's it. But you're going to want to be in a court of record where you have the upper hand, because they don't hear you as their statutory courts are for persons, and so they can't hear you when you're talking as a people. And in my court, the judge asked a question. I said, by what authority are you doing this? And I asked him, are you a person? And he wouldn't answer. I said, if you are a person, I can't hear you. I'm a people. If you're a people, then I'll answer your question. What are you, a person or a people? And he wouldn't answer. And I said, by what authority are you asking as a person, a people, to do something or ordering in this court? I told him I'll stand or sit as I please. It's a public building, and no person can tell a people what to do. And he got two bailiffs to try to scare me, and they did nothing at all because I was a people, and he knew that he had no jurisdiction to throw me in jail, as he was trying to say he was going to do. So there's going to be a fight in their courts, but if you don't know who you are and you know who they are, then you're going to lose, because he knows how to get you in your jurisdiction. If you take a toothpick out of your mouth and he tells you to do it, you're in his jurisdiction. You don't want to fight in there unless you know how to do it. You want to do a court of record, then now the tables turn. And so they're the ones that have to fight, and they're talking as persons in your court that is for people, and now you can play the game and say, sorry, that's dismissed, just like they do to you in their courts.
If I may, I understand what you said, but is it beneficial you need to put some things, challenges of jurisdiction, et cetera, in, at least get some stuff in the case? And how do you use everything that you already had put in the case in the inferior court? Can you just bring the whole record showing all the affidavits or anything, the unresponded to affidavits, and carry them right over to the counterclaim?
Okay, I'm going to have to. No. I'm going to have to step in here for a minute, and sir, I'm sorry. We have a lot of different listeners on this call and stuff, and we've tried to answer your questions. You're going to have to go to the website, and you're going to have to do some research on your own. And
I just wondered if that was a very simple question.
Well, I know, but you've asked some of the same questions over and over again now.
Yes.
No, I didn't ask that.
So
I've
got to respect
if I
other
get an answer
people.
To that question.
I've got to respect other people here. So what you have to do, sir, is you have to file a counterclaim and a court of records. And once you do that, it's your court. Okay? That's what you have to do. So you can either go to afreecountry.com or you can go to 1215.org. You can get samples at either place, and you can use those samples. Okay? So
I'm asking, is it appropriate to use anything from your that you have put in the?
I can answer that.
Go ahead.
The vast majority of the affidavits and whatnot that you submitted are completely useless in the court of record. You need to start fresh with the counterclaim, and all the affidavits wouldn't even bother with.
Mm-hmm. Thank you.
You can use what documents they filed against you as an attack on you, and that's evidence in your case. But otherwise, I wouldn't bother with whatever else was in the case, except for maybe documenting in a counterclaim properly what you were attempting to use as a defense in the inferior court. I yield.
If I may. Chief Murray out of Florida.
If I may. Chief Murray, how are you, sir? What is your question?
I'm focused. Every day is a focus day. If you're not focused when you get up, go back to bed. Anyway, my suggestion...
try to speak into your phone a little more so we can hear you. You're a little down, or turn your volume up on your phone, please.
All right. My suggestion is everyone that's going into court, do not go into court and try and stand there toe-to-toe with these judges.
Mm-hmm.
First thing is, the marshals that are in your area, the continental marshals that are in your area, and any notaries that you know that are in your area, I suggest that you take at least 2 of them to court with you, because they need to be a witness to the fraud that the judges are doing on the bench. Then they need to come out of the court with you without you arguing or doing anything, and they need to put an affidavit together. It needs to go back to your grand jury in your particular area, and you need to go in there based on the grand jury and decision made by the justice that's in your area, and you need to file a claim against that judge and the fraud that he's committing.
Well, and if you don't have a grand jury for those and people that without grand juries, you can do that in your court of records as well.
Mm-hmm. Okay. But I'm just saying, it's time for everybody to start going to court, not by yourself, and having at least 2 or more witnesses there to do affidavits right after you come out of your court hearing, because now you have justification to go back and have that judge removed from the bench because he's committing fraud.
That's correct, sir.
If I may, is it possible for a marshal to also be a notary?
Yes.
Wouldn't that be a great program to... Boy, the marshals can make some extra funds if they're also notaries.
Well,
and they're killing a couple birds with one stone, proverbial stone.
Well,
not about
and you can't. Let me correct that. That you can't be a notary for the government if you're a marshal. Okay, you can be an international notary, a sovereign notary, but you cannot work for the government and be a marshal.
Okay, good. So I need the application.
Correct that so that we don't have anybody misunderstanding that. Somebody that is a sovereign cannot work for the government, people. Okay?
Okay.
But, all right. But what happens if it's a de jure state? De jure, when you're a notary, you're an agent for the Secretary of State.
If you're an international notary, then that's okay. You're de jure still, and that's why I stated that. And remember, every state is a nation unto itself.
That international notary, what is that under what jurisdiction? Is that the UPU, the Postal Union, or something like that, or what?
Correct. That's correct. Okay, it's not under the state government. It's under the de jure state.
Where's the information on that? It's like a little manual or guidelines to see who's applicable.
You know, all of that stuff is in the UPU, but a lot of it is hard to dig up. We have done some of this throughout the years, so I'm aware of it, but I don't remember where I found it at this point.
That's significant.
Yeah,
that's significant.
I think you can just look up international notary, and you want to be an international notary, not a state notary.
Wow.
Okay?
Might be significant.
Well, I know one person that is an international notary and went through that, and that's the only reason I know that. So,
is it possible to get that person on the show and maybe explain a little bit sometime?
She has been on the show before. It is Cookie. So I'll try to talk to her and see if she wants to come on and share some of that information. It's going to depend on, you know, how many other people want to hear that information as well. But anyway.
Wow. That would bring cases in the international venue. And I do have another question. The gentleman said before, number one was, I invoke the laws for the Republic under Yahweh's law and truth alone. Should that be, I evoke the common laws, the common law of the Republic, or the laws for the Republic? Shouldn't the common law be in there somewhere?
I'm going to recommend that you don't do that, and that's what Justice Hamilton and I were saying. Just invoke a court of records exactly how Justice Hamilton stated, and you know, that's the best way to go about it. And you know, we're trying to make sure that we don't confuse people, and it's not that his way of doing it was incorrect, but I would still choose to use Justice Hamilton's way of doing it. Okay,
I evoke a court of record under common law for the Republic.
Okay, if you want to do it that way.
Is that correct?
Okay. No, actually, Justice Hamilton, you want to state how you invoke your court of records, please?
You would say, comes now, Stephen, a people of Pennsylvania, of sound mind in this court of record. I do believe I emailed you a sample of a counterclaim.
Yes, I do have a sample. I can't remember if that's in the front paragraph or not. I have to go and review that again.
It is. Well, it's getting late, gentlemen. And ladies, I'm going to have to bow out and go get some rest. I'm tired.
Thank you, Justice Hamilton. I appreciate you joining us tonight.
Yes, sir.
You,
take care. It's my pleasure.
All right.
Thank you. Take care. Bye.
Okay. Do we have? Yes, you may.
This is Marshall Benson in Las Vegas. I just wanted to share how easy it is to use this court of record. We've got a Perla Hernandez who was in a foreclosure. We started the court of record knowing that they were going to move to eviction. We knew that because they posted the 5-day notice to quit. And the next step after that is they take you to unlawful detainer eviction in the lower court. Here it's the Justice Court. So we got that set up, the court of record, and the alleged new owner, Stonecrest Acquisitions, took her to a summary eviction in the lower court, in the Justice Court, and she had one shot to make an appearance, one shot to stop this. She showed up last Tuesday and submitted a temporary restraining order to the lower court, basically telling them, excuse me, this is already in a court of record, and cease and desist. And the judge, I was there, and the judge from the bench said, "This is nonsense. I will not obey this order. I'm ordering that Perla Hernandez be immediately evicted. Told the clerk of the court, I'm ordering you to immediately notify the constable of her immediate eviction." And she objected, and we all left. And I'm thinking, holy crap, she's getting evicted. Well, Tuesday goes by, nothing. Wednesday, Thursday, Friday, Saturday, Sunday, nothing. Monday, my wife checked the record, and the judge closed the case. There is no more eviction. So,
Tom, did you follow that up with or you should have followed that up with a writ of error to the judge? I hope you did.
We didn't have to. I've got it.
I still would have filed it. So that case doesn't come back and bite you.
Honey, did we file the writ of error on that? Yeah. No. I'm mistaken. There was a writ. We did file a writ of error on that case, and that was filed on Wednesday. And then by Monday, that case was closed. So yes, sir, there was a writ of error. Yes. Yeah,
absolutely. That's all you should have done is just file a writ of error and then close the case.
The judge closed the case. The judge closed the case. There was no eviction.
Well,
but I just wanted to show people how easy this really is. It's not hard. It's not complicated. Just go to like you said, Judge Doucette, go to afreecountry.com. You can actually look at Perla Hernandez file. Everything we've done is on her file. And with that, I yield.
Thanks, Tom. I appreciate that. Yes, people, court of records really do work. And we really can help you with all of those in all cases. And you have to remember, when it's a court of records, it's your court. Anything that the inferior court tries to do that you don't like, you just, deny their orders. And, you get to write the ruling in it. And the ruling is exactly what you want it to be. And they cannot stop it. This is a very powerful tool. Yes, you may, sir.
When is this possible at all to be used, the court of record? Does there absolutely have to be a counterclaim filed in federal court, or could one, if one is forced by any reason to go or compelled by threat, etc., to go into a hearing at an inferior court, can one evoke this at an inferior court where it is absolutely not a court of record, and even the judge says this is not a court of record? Can one would this have any merit in effect? Yes or no?
You have to remember something. You can try to invoke a court of records, but you are a people and they are a person, so they don't have to hear you. And that's why, really, you can't do it without paperwork. And you want to make sure that when you file that court of records suit or claim, that you take it to the county clerk and you record it there first for the public records. Okay? Because that way they cannot deny it. So you're correct in your theory that you're thinking, Stephen, but you have to remember it's their court, so they can't hear you. So if you don't have paperwork that is filed with the as public record to start with, then they can just ignore you, like they don't hear you.
But if I may, the problem is at the lower, really inferior courts, there is no there's no file in the clerk of court, because it hasn't gotten. It only gets the file only gets developed in the clerk of court in one of the counties in Pennsylvania when you appeal from the magisterial level, the district magistrate level, up to the court of common pleas, it's called.
You're trying to file that in the wrong place, sir.
Or you mean you put it in the magistrate's file with the clerk at the magistrate's office? Is that what you're saying? Just so it's in their file?
No. You go to your county clerk, okay, where you file your land titles, and you put it in there as a public record, and you get a certified copy of it, and then you file that with the court, and they cannot ignore it. If you file directly with the court, then they can ignore it. They can say we didn't get the paperwork.
I see that. It could have to go under like general land deeds or some miscellaneous file in the court.
And you get a certified copy of that, and you file that with the court, and then they cannot ignore it. It's already public record. Okay.
Yes, sir. Thank you.
Okay, you're welcome, sir. Okay, people. Any other questions or comments? Getting late here. We've already lost Justice Hamilton. So any other questions or comments either on quarter records or on the biblical stuff we were talking about earlier?
If I may, I do have one other brief question. If one needs to go in and you want more time, let's say your court date is coming up in, let's say, 5 days, and what would be the appropriate document to file in the a miscellaneous file at the recorder's office to have a stay to instead of getting like let's say the chance getting another continuance, you don't have an attorney or whatever, you've been seeking counsel, can't find counsel, but they deny that. They say, you tried to find counsel before and we can't give you another delay,
Steve,
but you need a delay to get.
You're still thinking in their court, sir. Okay.
A delay to get your federal counterclaim filed. If there's not enough time, you don't have enough time.
It takes you as much time to file the counterclaim as it does anything else. Really, all you got to do is go to 1215.org and cut and paste the counterclaim that Bill Thornton has in there and file it. So really, you're making this way more complicated. Okay?
Thank you.
Just do it.
If I may.
Go ahead.
Also, guys, if let's say you have to go to court tomorrow, okay, and you don't have time to file your counterclaim, challenge the jurisdiction of the court. That's part of your counterclaim anyways. That's step A for any of this that we do. Step A is the counterclaim. I've got 5 people I'm helping that I haven't had time to help them with the counterclaim, and they just go into court, they challenge jurisdiction. And then, you're going to have another hearing, guys. You're not moving straight to trial. So before your trial, just go into court, challenge. Hey, I challenge the jurisdiction of this court. How do you have jurisdiction over me, the living man? I'm not a U.S. citizen. I'm not a U.S. resident. I'm one of the people of one of the several states. If you just do that alone, that'll get you through that court proceeding, and then you could do your.
So you say they will always continue. They will all usually continue it. What's the correct terms, correct wordage to say? I've been challenging jurisdiction all along. I've challenged jurisdiction. You failed to prove your jurisdiction. You're still failing to you're either going to dismiss the case, or I'll agree to give you another 30 days continuance until.
No, you don't agree to give them anything. You object to everything, but that jurisdictional challenge will get it on the record, and you're going to use that in your court of record. Say, look, I've challenged the jurisdiction. Here's my court of record. That's going to buy you time.
Already in there, but when you go, they try to slide it. They try to slide it. You know how they try to slide it through? Oh, boom, boom, boom. You're guilty, and that's it. So how do you prevent that from happening? There's not even a plea in.
You start your court of record. Now, anything that happens after that point, you are going to instruct the judge, excuse me, this is a court of record now, and you do not have permission to make any orders, okay? And you're going to issue a writ of error. Go to Perla's Go to freecountry.com. Go to Perla. Everything's there.
Okay, Steve, I got to stop trying to answer your question, sir. Okay?
Okay, I yield.
Told you the same thing.
That's all I needed to ask. Thank you.
Okay, all right.
I hope it helps. I hope it helps others.
Okay. Any other questions or comments? Going once.
Yeah,
Going
hi, Bruce.
Hello, dear. How are you?
Hi, I'm okay. Long time no talk. I have a comment about. You have a comment about the biblical stuff, and then about the invoking the Republic. Let me do the biblical thing first.
And this is Judge Mickey, right?
No, this is Jody.
Oh, Jody. Okay, I'm sorry. You and Justice Mickey sound a lot alike, so I haven't been able to distinguish you two's voices yet. Go ahead, dear.
Okay, I haven't been on the calls in a long time either. It's good to hear your voice as well. So anyway, regarding, because I got on the call late and I'm not familiar with the indigo flower. So forgive me if I'm repeating something that you've already spoken about. But, so regarding the words, did she say anything about the word mark, like what the word mark really meant?
With the mark of the beastman?
Well, in the Bible it talks about missing the mark, and it says don't take the mark of the beast.
Yes.
Usually everybody
goes
thinks
through that. I believe in, I think that is her Genesis 3 review. I don't know. She's got so many of them, and I've listened to them all. But yes, she does talk about the mark.
What does that mean?
It's like you puncture the skin with like a hypodermic needle.
Oh, okay. Well, is it referring to a tattoo then?
To a chip, did you say?
There are several things that she talks about with the mark. So not just one thing. She talks about the chip. She talks about the tattoo. And she talks about the very fact that, using credit cards and stuff is also a mark. Okay.
All right. I just kind of wondered because, I don't know everything about what she says and just trying to decipher. They say in the Bible that sin is missing the mark.
Yeah.
So does that mean, and you can help me out with this, Bruce, because I don't know if I have my thoughts all together on this. So if that's the case where we're missing the mark, which if you use the word autograph or signature, then that means there's no autograph, as in like how they do this fraud against us without our signature or our autograph, which is technically a sin because they're defrauding us, right?
Right. She doesn't go into that specifically as far as signatures. I don't believe, and I'd have to remember. I mean, she's got a lot of stuff. It's really going to open a lot of people's eyes if they will at least consider what she says. And then my challenge to you is don't just consider what she says, go and try to prove her wrong. Because I've tried to do that on a lot of things. Now, she's got a couple of things that I do not agree with how she interprets them. Like the fact that, in Genesis 1, she says that, the Elohim terraformed the earth, and they may have done some form of that. I tend to go with the Book of Enoch because it's got a very descriptive view of how the earth and everything is set up there. I believe that that's more correct, and they actually created more than she probably does. But still, she's taking a very logical look at it and trying to find the truth. I really believe that she's an honest person, and that she really is trying to figure out, okay, what really is the truth here.
Right. I think that's the quest that we're all on as well.
There you go.
And Right, exactly. So I'm just wondering if I was like right on with my thinking, not being exposed to, what she's, teaching.
You're going to have to go. I don't know that from just listening to what little bit you said, Jody, but I think you have to go listen to some of these, and you have to go into them with an open mind, and then let the Spirit show you what's true and what's not. Use your own discernment. And if you don't agree with her on something, then go find the truth yourself. But she does a pretty good job of taking every single word in every scripture and trying all of the different meanings for that word. And she's not saying that this is it, but she's saying this one is the one that seems to make the most sense for the exact times that we're in. And I tend to agree with her on that. So it's really interesting.
Do you think do you think it would be possible that can I ask a question?
Yeah, go ahead.
Do you think it would be possible, regarding the words, the mark of the beast from the Bible, could that possibly mean the all cap name? That we should not take that?
I hadn't looked at it that way. I'll have to go back and try to reconsider that way. You may.
If I may. No, the mark of the beast, they specifically say that you're going to take it on your hand or your forehead, so that wouldn't be a name. I yield.
Okay, thanks, Tom.
Yeah, I've heard that. I've heard that before. I've also heard that when they refer to the forehead, it could just be simply a thought, that it's in your forehead, not on it.
This is your producer.
Hey, Toasted.
Okay. Well, let me just ask, if I may ask the next question.
Hold on just a second.
Sorry, just make a comment.
Jody, hold on just a second. Toasted needs in here for a second. Go ahead, Toasted.
I'm running out of gas for the night. Just letting you know I yield.
Okay. All right. We'll try to wrap this up and then Toasted. Okay, Jody, go ahead.
Just one last comment then about the invoking the Republic. I was taught that if you do say that when you do that, no attorney can be in the courtroom at that time when you do that they, for whatever reason, they have to leave the courtroom, and I guess that the judge will then dismiss the case.
That might be a possibility. I don't know that for certain, and until I know somebody that has actually tested that personally and can come on and talk to us about that, I would have to be very careful about putting that information out there.
Okay.
I think
I'll find out. I'll try to find out if the person that told me if they've done it personally or if they know someone that has. But I got it from a source, so I can give you a call and just talk about it a little bit more if you would like me to.
Yeah, if you can show me somebody that actually has done it and is willing to come on and talk about it, and if that worked, then I'd be happy to put that information out there. We try to put out the truth. And at least for the Court of Records and how Justice Hamilton is doing that, we know that works.
Yeah, I've heard good things about the Court of Records. So I'll try to find out if that's the case, Bruce, and I'll get back with you on it. I know how busy you are. But anyway, thank you for letting me talk. I yield. It's nice to hear your voice again, Bruce.
Thank you, ma'am. Okay, any other questions or comments? Going once. Going twice.
If I may.
You may. Go ahead.
Hello, Justice Doucette. This is Marshall Schubert. I wanted to throw something at you.
Go ahead.
Since you're giving us homework. Can you hear me?
I can. Go ahead.
Okay. I told Justice Mickey to check out the video "No Forest Like Forest on Earth." Has she told you about it yet?
Somebody sent me or somebody posted that on my Facebook, And I wanted to take and look at it. I haven't had a chance to yet. You want to give us a quick synopsis about what it's about?
No, I don't. I want you to watch it, because if I do it, I don't do it justice. And everybody thinks they got the gist of it because of what I've talked about. But it goes into what the lady was just saying about terraforming and the giant trees that were here on the earth that had been cut down. I mean, giant trees, miles.
I will take the time to go and research that. Thank you, sir.
Thank you. You have a good evening.
All right. Anyone else with questions or comments? Going once, going twice. And thank you, everyone, for another Sunday night. I hope it was educational to everyone. And we'll look back to see you here all next Sunday evening. Thank you all, and good night.
Could we have that website again? Could we have the website again for us? Something or other?
A free country. Do you want a freecountry.com or
the forest one? The forest one.
Oh, if I may,
go ahead.
I'll speak.
Go ahead.
It's on YouTube, and it's a video, and it's called No Forest on Earth.
Thank you.
And it's an English voiceover, because the original version was done in Russian. And the guy has such a heavy accent, most Americans can't understand what he's saying. So you want to make sure you select the video that says English voiceover.
Okay.
Thank you. I yield.
All right. Thank you all. Good night.
Night. Thank you. Great call.
Call recording off.